they are on a fishing expedition. But even on their fishing expedition, they have not found fish. But I'm here to West Coast time.
What does it mean?
The implication is that having set the 22nd of January as the date of ruling, it goes without saying, the Honorable Waiswa Mufumbiro will not vote for himself as Member of Parliament, Nakawa East constituency.
What transpired today in court about the Mufumbiro's case?
Today, the matter of the Honorable Alex Waiswa Mufumbiro was mentioned in court in Nakawa. 78 days since he was charged in that court. You remember that he was charged on the 22nd of October 2025, and on the 13th of November 2025, we made an application for bail on grounds that the trial would take a long process, especially that the state had not concluded its investigations. Bail was denied on grounds that since investigations were still ongoing, the status of the Honorable Waiswa Mufumbiro can make him influence the investigations, and court directed the state to conclude the investigations as soon as possible. Now, close to 2 months down the road, that directive by the court was not respected, because the state this morning submitted that investigations were still ongoing. We found ourselves in a situation where court capped and tagged our reapplication for bail on completion or conclusion of investigations. So we realized that the state is not concluding investigations so as to disable Honorable Waiswa Mufumbiro from reapplying for bail, given that condition that was set by court. But the law was alive to such issues. That is why the legislators enacted Article 23, 6B. They enacted Section 76 of the MCA, and most recently we have Regulation 9 of the bail guidelines. All speak to one thing. If an accused person like the Honorable Alex Waiswa Mufumbiro has been remanded for a period exceeding 60 days, he is entitled to immediate release on mandatory bail, which may be granted by a court even in absence of an application by the applicant. The constitutional command is upon lapse of 60 days, an accused person whose trial has not commenced, whose investigations are still continuing, has to be released on bail on reasonable grounds to ensure that he'll appear in court whenever required for trial. So today, that is the ground, that is the basis of our application for mandatory bail. So we made an application. Having been disabled on one arm for want of concluding investigations, we chose to apply the law for release on mandatory terms. So we made that application today, and we believe the court has no choice, because it has no discretion on determining on whether to release or not. Court is only enjoined to grant conditions for that release that would enable the Honorable Waiswa Mufumbiro return to court whenever he is required. The law again provides that the court does not have the powers to grant conditions that would defeat the intention of mandatory bail. So on all that put together, we believe on the 22nd date of February, 22nd date of January, the Honorable Waiswa Mufumbiro, if the law is applied, should be released on mandatory bail by the court.
What does it mean?
The implication is that having set the 22nd of January as the date of ruling, it goes without saying, the Honorable Waiswa Mufumbiro will not vote for himself as Member of Parliament, Nakawa East constituency. But again, we call upon the judiciary and the judicial officers to always be case sensitive. The law says in such a case that every case has to be treated on its special circumstances or cases. This was so special a circumstance that it is very apparent court was alive to the fact that there is an election coming on 15th. That it adjourned the matter for ruling beyond 15th is indicative of the judiciary's workings under the political arm of government or the state. So the ground is not leveled in that field. We just pray that it should be leveled. Courts should not look at the color, political party affiliation. It should treat the Honorable Waiswa Mufumbiro just like any other Ugandans. But we believe that influenced the decision not to give a ruling, which albeit would not even need 2 days. Court is enjoined to just count days as they exceeded 60 days since the person was charged. How much more time do you need to make such a decision of counting, especially where the state did not oppose the fact, like it was in Dr. Kizabesi's case, that the time had not lapsed. So I think this was a bit unfortunate, but nevertheless, we shall wait on the 22nd of January to see whether he will come out to celebrate his victory, even when he will not vote for himself. So it's a clarion call on people of Nakawa East constituency that faced with such a situation, the matter is not in our hands as lawyers. The court has made a decision we cannot change. We shall have to respect. Now the ball is in your hands. It is in your court to come out in big numbers to compensate for that one vote lost. That is how you win here and probably in court. Because we are yet to see a situation where someone has been voted as an MP, is incarcerated. What will happen? The swearing in ceremony. That situation we are waiting to see. And such are matters where court is enjoined to consider the circumstances of the case. You have a honorable member of parliament elected as of right. It's in such circumstances that a person will ordinarily be granted bail so that he serves the people that have elected him. So all these probably will be considered by court in deciding to release the Honorable Waiswa on reasonable grounds.
Is there a need to enforce or to reform the law that it allows prisoners also to participate in
this
voting?
Is one such case that supports our argument at all times on the right of prisoners to vote. A person being detained, even upon conviction, does not take away a person's right to vote or to participate even in election exercise. It may take away the right to stand upon convicted. But those on remand, you can even stand, just like the Honorable Waiswa Mufumbiro. So if you have the right to stand, if you qualify to be nominated, then you qualify to vote. That you've qualified to be nominated, to be elected, and that you do not qualify to vote. That is a mischief that ought to be resolved by clarity on electoral laws, by accepting or granting detained people or prisoners the right to vote, like we've seen in other jurisdictions.